Hello, and welcome to the Family Law Orientation, also known as the Flow. My name is Christina. I'm an attorney who works for King County Superior Court, providing general information, not legal advice. In this video, we are going to be reviewing how you can ask for an order of default when the other party has not filed a response to the petition that you have filed. There is a deadline for the other party, the respondent, to file a response to the petition. If you arranged for the other party to be personally served in Washington State, they have 20 calendar days. So these are regular days, 20 days in which to file a response to the petition. If personal service occurred outside the state of Washington, that's 60 calendar days in which the other party has to respond to your petition. Or if you obtained permission from the court to serve via publication, they have 60 calendar days in which to respond. Or if you receive permission from the court to serve via mail, then the other party will have 90 calendar days in which to file a response to your petition. That response to petition form is going to look something like this. This is an example of the response to a petition for a divorce or legal separation case. This form needs to be filed with the clerk's office, and a copy should be served to you as well. Always check the court file before asking for an order of default, because sometimes the respondent will file the response with the court but not provide you a copy. But even if they haven't served you a copy, you will not be allowed to proceed and ask the court for an order of default. So again, always check that court file first, because at any time, if a response to the petition is filed, you will not be able to proceed with default. So what happens if the response is not filed by that deadline? Well, you can go forward and ask the court to enter an order of default. And if the court approves that order, then you can move forward and finalize the case. And you would be entitled to everything you requested in the petition. But please note that even if it is past the deadline, and if the response to the petition is filed, you will not be able to ask for default. Let me say that again. So if the response to the petition is filed past the deadline, you cannot proceed with default. So there's no consequence to filing a response to the petition late, other than you being able to ask for default. But if the response petition is filed before you can get to the court and get your order of default, then you're proceeding to trial, or you can finalize the case by agreement if you do reach an agreement. But default will no longer be an option for you to finalize the case. So if you do qualify to ask the court for default because there's no response to the petition that has been filed and it's past that deadline, there's two different routes that you can take. If the other party has participated in any way, you need to provide notice to the other party. So you'll have to file a motion, schedule a hearing to let the party know that you will be seeking an order of default. If there's been no participation at all from the other party in the case, then you are not required to provide any notice. Some examples of participation will include going to a parent seminar or this family law orientation class, also appearing to a hearing, or filing any documents in the court case. When the other party has participated in the case in some way, you will need to set a hearing and notify the other party of that hearing date. Step-by-step instructions, including hyperlinks to the forms that you need, are available online on the facilitator office website. We do have a link to those instructions in the description box below. And if the court does approve the order of default at the hearing, you can proceed to the next step. That is preparing the final orders and providing them to the facilitator's office, and they will then assist you with finalizing the case. Those proposed final orders have to be exactly the same as what you requested in the petition. So when you are finalizing by default, you're not allowed to change what you've requested in the petition. So again, your final orders, the content of your final orders have to match the content of the petition and the requests that were made in the petition. If the other party has not participated in any way, you can ask the court to approve your order of default without notice to the other party. So you would prepare your motion and order for default and provide those documents to the facilitators along with your proposed final orders. You want to check the Family Law Facilitator website for instructions on how to submit those documents to that office. And we do have a link to that website in the description box below. So if your final orders are approved by the court, so that is a judge or commissioner signs your final orders, then your case is finished. But if your order of default is not approved, your case will remain open and you will need to make sure that you're prepared for the next steps in your case. You should be trying to reach an agreement with the other party. If you reach an agreement in the case, you can watch the video on finalizing by agreement. If you need some type of court decision to be made now, so perhaps you need a temporary parenting plan, you need some decisions to be made on who's going to drive what vehicle until the divorce is finalized, you want to watch our videos on motions. And it's a good idea for everyone to watch the Important Court Deadline series of videos that are going to walk you through the important case schedule deadlines that you do need to be complying with. And some party reminders here, until those final orders are approved, you need to follow those case schedule deadlines. If you do have questions about how to meet those deadlines and what the next steps in your case should be, you can visit the Family Law Facilitator website. If you want to speak with the facilitator, please visit the website for instructions on how to connect with the facilitator, or you can also call 206-263-FLIC or 3542. There are additional resources available in the community to assist you, so please use that resource list that we have a link to in the description box below for additional legal assistance. All right, thank you.